This conference will now be recorded.
Good afternoon. My name is Ellen Makovsky, and I am an attorney whose practice concentrates in elder law and trust and estates. My offices are in Garden City, right in front of the Roosevelt Field Mall. This past year, in January of 2020, I received a Lifetime Achievement Award from the New York State Bar Association Elder Law section. I was named as a top 50 woman super lawyer by Super Lawyers. I have served as president of the National Academy of Elder Law Attorneys. I have served as president of the Estate Planning Council of Nassau County. I have served as chair of the Elder Law section of the New York State Bar Association. My colleagues think I know what I'm doing, and when this presentation is concluded, I hope you are feeling the same way and that I've given you valuable information to help you out. So the topic for today's presentation is don't let Medicaid place a lien on your house. If you have any questions about the presentation or something that I'm saying, you'll see those little people signs on the information strip for the GoToMeeting webinar. You can click on that and you can post any question you would like in the chat section. And Michael, who's standing by, will be relaying the questions to me as we go. So let's go forward and talk about how to prevent Medicaid from placing a lien on your house. Let's first talk about Medicaid. Medicaid is an entitlement program, which means that it's different from other insurance coverage you might have. It's different from Medicare. It's different from private insurance program. Medicaid is a program that in order to qualify for the program, you need to have very little in assets and income. When talking about the Medicaid coverage, I am going to be talking about two different types of long-term care coverage. We have what's known as community Medicaid, and this means that medical services are being sent to your home to take care of whatever your particular needs are. And one of the major benefits of being a recipient of community Medicaid is that you can get a home health care aide sent to the home to help you out with your long-term care needs. The other type of program that is provided under Medicaid is the nursing home program, and that is exactly what it sounds like. Medicaid will pay for your care in a nursing home pursuant to the rules laid down by Medicaid. There are all sorts of misconceptions about Medicaid and Medicaid coverage. One Medicaid myth is if I apply for benefits under the Medicaid program, Medicaid will take my house. This is a myth. Medicaid can never take your home from you while you are living in that home. What Medicaid can do is it can determine you are not eligible for certain Medicaid benefits if you own your own home, and Medicaid can place a lien on your home, but they can only place that lien on your home in an amount equal to the monies that were actually spent on taking care of you. They can't just take your home. Let's talk a little bit about the eligibility criteria for Medicaid, because you need to understand this from the outset to understand how the lien mechanisms work. So in order to be eligible for Medicaid, you can only have $15,750 in assets or resources in Medicaid speak. $15,750 in assets. There are certain assets that you might own that are known as exempt assets. So Medicaid is very generous. They will allow you to prepay for your funeral and your burial space, and they don't count that as part of the $15,000 in assets you're entitled to keep. In addition to that, Medicaid will consider any retirement account, such as an IRA or a 401k or a 403b, some retirement asset that you own is considered an exempt asset that doesn't count for Medicaid eligibility. In the resource category, they will count the minimum distributions that you get as part of the limited income that you can keep as a Medicaid recipient. And then finally, there's what's known as the homestead exemption. And the homestead exemption will apply if the house that you own, your home, is valued at less than $878,000. When you meet that limit of having a house that is valued at no more than $878,000, and you meet the other required criteria, your home is exempt under the homestead exemption. And you can meet this homestead exemption if the Medicaid recipient is living in the house or has an intent to return. The value of the house is exempt for Medicaid eligibility purposes. Where the healthy spouse resides in the home, even if the sick spouse is in the nursing home, that the home comes under the homestead exemption. Where there's a minor, disabled, or a blind child who lives in the Medicaid recipient's home, again, you get to keep the homestead exemption, and the house does not count for Medicaid purposes. It is exempt when looking at Medicaid eligibility criteria. Even though the house is exempt, while you are making this application for Medicaid, Medicaid has a right to later place a lien on the house for the value of the monies that Medicaid has spent on your care. So even though it's an exempt asset, at a later time, Medicaid has a right to impose a lien upon your house. And what a lien means, when you have a lien on your house, what it means is the house cannot be sold or transferred until that lien is paid off. However, the Department of Social Services is unable to enforce any lien on your house when certain people live in the home. So we've spoken already about the spouse. When the healthy spouse is living in that home, no lien can be imposed. When a minor child lives in the home, no lien can be imposed. When there's a child who is disabled or blind, again, no lien. When you have the situation where you have a sibling with an equity interest in the home, no lien. And what this means is where you have a sibling whose name is on the deed, or who has made some contributed their own money to make some substantial improvement on the home, they're said to have an equity interest, some ownership in the house. And you know, sometimes we see this where mom and dad left their two children the house when they died, and brother and sister never got married, and they are living together in the family home. They're said to each have an equity interest in the house. So if sister went to the nursing home and brother remains at home and his name is on the deed, Medicaid cannot impose a lien on the house. And then the final situation where Medicaid can't impose a lien on the house is where you have a caregiver child, an adult child who lives in the house with the Medicaid recipient and has lived in the house for 2 years prior to the application of Medicaid. Medicaid cannot impose a lien on the house when this caretaker child is living there. However, when the exemption disappears for one reason or another, Medicaid can impose their lien on the house. And so this happens in the situation where you have a single person who has no children living in the house, and he or she is receiving Medicaid at home, that community Medicaid, and the individual dies, Medicaid can now place a lien on the house for the amount of money that was expended on the Medicaid recipient. If you have a single person where no children are living in the house, and the Medicaid recipient can no longer be maintained at home, and they require a nursing home, and the house is left empty, Medicaid can impose their lien. When you have a spouse, minor or just minor child, disabled child, or blind child living in the house, and all of a sudden the spouse was living in that house, so you had the exemption, and the healthy spouse dies first, leaving the Medicaid recipient in the house, and the spouse, the death of the spouse results in the exemption disappearing, and Medicaid can now place a lien on the house. But remember, the lien can only be made in the amount expended by Medicaid on that Medicaid recipient. So how do we prevent liens from being placed on the home? Well, the way to prevent a Medicaid lien being imposed is to transfer the home in one way or another. And there really are a variety of ways to make transfers. So let's discuss those. And let's discuss the pluses and minuses to the various types of transfers. So first of all, we can do the very obvious thing. We can make an outright transfer of the house. And what that means is there is a deed drawn up, and the deed goes from Mary Smith to her daughter, Sally Smith. It's an outright transfer. Mom gave the house to her daughter. When mom makes that transfer of the house, mom no longer owns the house. It's an outright transfer. And there are benefits and disadvantages to making an outright transfer. When you've made an outright transfer of the house, you no longer own the house. Medicaid cannot place a lien on the house. So you've accomplished that goal. However, when you've transferred the house, you no longer own it. Your daughter, Sally, can now just turn around and sell the house and put you out of the house. You have no more rights to the house because you've made an outright transfer of the property to somebody else. If daughter Sally has creditors, Sally's creditors can attach the house, can force her to sell that house. And again, you no longer own the house, you have no further rights to the house, and you have no way to protect your right to live in that house anymore because you've made an outright transfer of the house to somebody else. There are also various tax implications for transferring the house outright to somebody else. Most people have various real estate tax exemptions that they get when they own the house right here in Nassau County. We have the STORE program that reduces your real estate obligations, your real estate tax obligations. Some people have enhanced STORE exemptions, reducing the real estate taxes that are due even further. Others have veteran exemptions to their real estate taxes. When you transfer the house to some third party, to your daughter, those real estate exemptions are going to disappear because the person who now owns the house may not be entitled to those real estate tax exemptions. So with an outright transfer, you might be responsible for higher real estate taxes on an annual basis. The other issue with making an outright transfer is capital gains tax. So when you bought your house many years ago and you paid what you thought was an exorbitant amount of money at that time, you bought your house and you spent $100,000 on it, and you've owned it for many years. And now it is valued at $500,000. We've had a very good real estate market in the local metropolitan area. So the difference between the $100,000 plus any improvements you've put in the house and the $500,000 that the house would sell for is what's known as your capital gain. If you own your house and you die owning that house, whoever inherits that house takes it with a value of $500,000. And if they turn around to sell that house and it's valued at $500,000, when they sell it, there will be no capital gains tax imposed on the sale of the house. When you gift a house to somebody else, they take that gift with your basis, which would be that $100,000. When the person you've gifted that house to turns around to sell it, they have to pay capital gains on the difference between the $100,000 and the $500,000 that the house was eventually sold for. And they are going to pay a capital gains tax of 15 to 20% of the profit that they received on the house, 15 to 20% of the $400,000 in that example that I just gave you. So Outright transfers of the house sometimes are not the best choice for a variety of reasons that I've just laid out to you. So another way to transfer your home is to transfer the home to somebody else who will have a future interest in that house, while at the same time maintaining for yourself what's known as a life estate. The right to live in that house for the rest of your life, the right to collect any rents that are received by renting out the house. And when you have a life estate, nobody can ever put you out of your own house because you have the life estate. And the person who has the future interest only owns that house at your death. When you transfer a house retaining a life estate, you also continue to get any of the tax breaks you were previously getting before you transfer the house, reserving a life estate. So that's a good thing. The problem with transferring the house and retaining a life estate is if you go on to that Medicaid program, you can never sell that house during your lifetime, because when you sell that house and you receive, and it's sold for $500,000, you are going to get a good chunk of that money back in your own name. Because when you have a deed that retains a life estate, the proceeds of the sale, a portion of it will go to the person who gets the future interest, and a portion of the proceeds will go to you because you have the life estate. And there is a percentage that's figured out that changes every year as you get older. Every year that you get older, you own less of the house and the future interest person owns more of the house. And it's all figured out by tables put out by the Internal Revenue Service. But if you're on Medicaid and you do sell the house and you do get a substantial check, and a person who is in their 70s gets almost 50% of the value, according to those IRS tables. Once you get that money back in your own name, you're going to be off the Medicaid program until those monies are spent down. So this creates some problem for those people who are interested in receiving Medicaid benefits and who are concerned, one day maybe the stairs will be too much. Maybe one day I can't maintain this house. When you transfer the house retaining a life estate and you're on Medicaid, it never makes financial sense to sell that house. And so then the third way we can transfer the home is gifting that house over to some sort of trust. And we're going to talk about that a little bit further in this presentation. So let's move forward a little bit and talk about the kind of planning we should be doing to avoid a lien being placed on your house. And really, there are two different situations. One is the situation where the person is already on Medicaid and they're worried about a lien being placed on the house, or they're about to apply for Medicaid. And then there is the other situation where Medicaid is not on the immediate horizon and you have some time to make a plan. So let's talk first about the situation where the individual is already on Medicaid or is about to apply benefits. What can they do to avoid a lien being placed on their house? Well, one thing that they can think about if they're a married person is to transfer the house to the healthy spouse. When you transfer the house to the healthy spouse and the sick spouse dies, and it doesn't affect the Medicaid eligibility, and the healthy spouse owns the house. When we are looking to avoid liens and we've transferred the house to a healthy spouse, we're going to do all sorts of planning to make further transfers of that house once the Medicaid recipient has been approved for Medicaid benefits. The advantage of transferring the home to the spouse is there are no penalty periods imposed for transferring a house between husband and wife. Another option that we have to avoid a Medicaid lien is to transfer the home to a caretaker child. That's that adult child who's been living in the house with you. The advantage of making an outright transfer to the caretaker child is no penalty period for transferring to a caretaker child under the current Medicaid rules in New York. And of course, everything I'm talking about today only applies to New York. Medicaid is a federal, state, and county program, and every state has different rules in regard to Medicaid. So what I'm talking about today only works in New York. And the third kind of transfer that can be made is transferring a home prior to the need for Medicaid at home. No penalty periods for making those transfers when somebody is applying for Medicaid. However, I need to caution you because there has been a drastic change in the Medicaid program in New York. And as of October 1st, there are going to be penalty periods imposed for transfers prior to Medicaid being provided at home. There are going to be penalty periods imposed for a look-back period going back for 2.5 years prior to the application of Medicaid. The regulations haven't come out yet, and we don't know exactly the mechanics of how these penalty periods are going to be calculated. But as of October 1st, there will be penalty periods imposed. And if you're thinking of making an application for Medicaid for home care, now is the time to do it before that October 1st date. So we can make, right now, we can make transfers of the home to the spouse, to the caretaker child, and to anyone if you're making an application for home care. Transfers to a trust are much more problematic because they, when you make a transfer to a trust, it's not an exempt transfer, and there will be a penalty period imposed for making that transfer to the trust. As I said before, transfers can be tricky. There are lots of rules and regulations imposed. When you are making the transfer of a house prior to the application for services in a nursing home, there is a 5-year look-back period. As of October, there will be a 2.5-year look-back period for transfers made when you're receiving home care. What happens is when you make the nursing home application, Medicaid will ask to see all of your financial statements going back 5 years, and they will ask for an explanation of all the deposits and withdrawals in excess of $1,000 during that 5-year look-back period. When you are creating this paper trail for Medicaid, Medicaid will determine what distributions in that 5-year look-back period will be characterized as gifts, and then they will impose a penalty period during which time you are not entitled to receive benefits in a nursing home. And the exact penalty period is figured out by formula. And what they do is it's just a mathematical formula. They take the value of the asset that you transferred. What is your home worth? And they divide that by this make-believe number they make up every year that they call the average cost of the nursing home in the particular county. And they come up with the number of months you are ineligible for Medicaid in a nursing home. So if you had a $500,000 home, the current number that Medicaid is using in Nassau County is $13,407. You divide that into $500,000 and you get 37.2 months, a period of over 3 years where you are ineligible for benefits in a nursing home because you gifted your house away. So making gifts of that house has to be done very carefully. So when people come into my office and they are concerned about losing their home to a Medicaid lien, they're concerned that they're going to lose the most valuable asset that they have, we start talking about trusts and how trusts might be used to solve that problem. Because remember, your house is not a consumable asset. You are not using your house to pay your grocery bills. You're not using your house to keep up your standard of living. You're just living in the house. And transfers of your home into a trust in no way are going to change your day-to-day life. Because you still can continue to live in your house once you've transferred the home into a trust. And if you transfer the house into the trust way in advance of thinking you're actually going to need Medicaid, you have no problem in regard to penalty periods. Because if you transfer your house into the trust, you wait 5 years and 1 day, there is no penalty period for making that transfer. So there are many different kinds of trusts, and the type of trust we use to protect your home is called a Medicaid Asset Protection Trust. And there are certain rules that must be followed so that Medicaid doesn't see your house as an available asset when it's owned by the trust. And so the rules require that the Medicaid Asset Protection Trust be irrevocable, meaning the terms can't be changed or amended at a later time. The trust, you cannot be your own trustee of this trust. You have to have your daughter, your friend, your sister as the trustee of the trust. The terms of the trust require that you can never get the house back out of the trust once you place it in the trust. You can have no right to get it back. Because if you have a right to access the principal of the trust, if you have a right to get that house back, Medicaid can also get the house back. We can put provisions in the trust allowing you to get any income generated by the real property held by the trust. The advantages of a Medicaid Asset Protection Trust are simple. You no longer own the home, and because you don't own it, it's not seen as an available asset, And Medicaid can never place a lien on your house because you don't own it. The terms of the trust are going to allow you to retain a lifetime use and occupancy of the house. And what this means is nobody can ever put you out of your house. The terms of the trust are going to require that you continue to maintain the trust and that you continue to pay the taxes on the trust, and that you keep the house in good condition. The house can be sold while it is owned by the trust, but the proceeds of the sale are never going to go back into your own pocket. When the house is sold, the check is going to be written out to the trustees of the trust, and the trustees can turn around. They can buy a smaller house, a more manageable house for you to live in. They can buy a condo or a co-op for you. They can buy a house down in Florida with you from the proceeds of the sale. And again, you will be able to live in that real property, but you will not own it. The trust will own it. They can sell your big house, and they can buy a house that costs less money for you to live in it. And the monies that were not expended on the new smaller house will be put into a trust bank account or brokerage account, and the income will be distributed to you by the trustee. When you transfer a house into a Medicaid asset protection trust, you get to keep all those real estate tax breaks you're currently getting. The STAR exemption, the enhanced STAR exemption, any veterans benefits you are getting that reduces your real estate estate taxes continue. And in addition to that, your heirs will get a step up in basis, meaning if you transferred your house into a trust at your death, when the house is transferred to your children, they get a step up in basis, and there will not be any capital gains taxes required to be paid when the house is sold, if it's sold for the same value as the appraised value on the date of your death. So what are the disadvantages of transferring a house into a trust? Well, the obvious one, you no longer own the house. However, your heirs will inherit the house. There'll be no lien on the house that needs to be paid off after you've died, and the heirs inherit the house without proceeding, without having to have a probate proceeding. So these don't seem like really big disadvantages to me. And those who are afraid to lose their house to Medicaid liens, trusts seem like a really good idea and something that you might want to consider. So I'd be pleased to answer any questions that anyone in our audience has. And if there are no questions, I thank you for your attention.